I think if this case is successfully carried out, it will be the final nail in the coffin of the constitutional republic.
We are growing tyranny through this case if it succeeds because we are consolidating powers in one branch. Hello, welcome to this edition of Defending Utah Television and Radio, and we are pleased today to have guest Dr. Scott Bradley. And today we are going to talk about this headline: the last failsafe to fix the 2020 election at the Supreme Court. So this is happening. This is national news. You can see this is not a small time thing. Lots of views, lots of attention happening here. So this case is something that Defending Utah has actually not talked about, and we've heard a lot about it. We've been around a lot of chatter and had lots of things sent to us, and we just thought to speak to it was not a simple one-line response, and so we haven't said much, but you can see here the attention this is getting. This is the case in the Supreme Court. You know, it's the new articles like this are just everywhere. This is like the hot topic of the day that everyone is kind of hoping for something. And so we have Scott here. We want to break down, what is this case? And is it a good idea? Is it exactly what we're told it would be? Is there a chance something good's going to happen? Or are there actually maybe some not so good things happening? And Scott is going to break down the constitutionality of the case, and on principles, we're going to discuss answers to these questions. So thanks, Scott, for being on the show today.
Glad to be here, as always. There's plenty to be discussed in this, and the brief time we'll spend on it obviously won't be a week-long review before the Supreme Court, but I think we got to hit some points on it, though I almost called them high points, but they really aren't. They're extremely concerning points. In fact, I think if this case is successfully carried out, it will be the final nail in the coffin of the constitutional republic. And hopefully,
Wow.
as everybody listens, we'll be able to see that this involves some great leaps, bounding leaps, in terms of issues like independence and co-equalness of departments and so on, constitutional phraseology that needs to be better understood. What has been presented has been not just glowing hopefulness. It has been almost hyperventilating hopefulness on the part of many in regards to how this is going to turn out. And I'll say up front that I believe that it's action before the Supreme Court. I usually say when something has very little chance for success, I usually say it's got two chances, slim and none. I would say almost categorically, the chance is none that this will move forward after the January 6th review by the Supreme Court.
And you were saying, even if it did move forward, people may not be getting what they think they're getting.
Oh, absolutely not. I think that we are in a place in America today that we've kind of, through the system, the educational system, and our, I don't know, our memory spans, our focus and ability to think beyond the given moment, I think we've lost largely the ability to connect the dots.
So being able to connect the dots, as you're saying, is, to me, that's a skill set that comes when you've mastered principles, and when you have a mastery of the principles of our constitutional framework, the principles of liberty and natural law that we were built upon, then you can judge things through that lens, which is different than judging it through the lens of what we sometimes call hopium, right? Getting excited about the headline that just somehow tugs at our heart, like they're gonna get those guys, right? And if something does get those guys, right, great when good happens, but being able to see things for what they are, I think, is a skill of applying principles. So when we master the principles, then just like Samuel Adams said, we can reason things out in our own minds as new issues come up, case by case.
Well, I think what we have here is an overdose of hopium, as you call it, wherein so many of the Patriot networks, the Patriot media, the discussions that people that have called me with such almost gleeful excitement about this, that they're not connecting those dots. They're not seeing. They're not able to see. And I ask them oftentimes, if this wins, what is the outcome, and where do we go next? And the things that they're saying basically are a military junta that's in charge of the United States. I mean, it's either that or an oligarchy of 5 judges on the Supreme Court that can rule on anything and have power and control over it. They're just not thinking ahead. And maybe by the end of the little discussion and presentation, we'll be able to see that that we need to think ahead. And a lot of times when people have something that they're really excited about, they come to me and I say, well, I'm sorry to tell you, this isn't going to happen. Of course, they usually get really mad at me when I tell them that, because I've burst their bubble. It's kind of like, if wishes were horses, beggars would ride. You've heard that phraseology. And in this case, we may get a pony ride if it wins, but what's after the pony ride is really, really a bumpy road if you think down the road a little bit further. And you look at what really we have as a constitution. It's an organic document that still lives. We can go back to it anytime, but I'm not so sure it's going to be possible if this wins. So I don't tell people, oh, I'm sorry, it's not going to win. I say, it's not going to win, and I'm not sorry. And that usually increases their anger.
Well, let's break this down then. So what we're going to do for you, the listener, is we're going to present. Scott Bradley has prepared a quick presentation here. We're going to walk through what this case is, what it does, and what are the principles behind it, and help us connect those dots better, as you say. So, Scott, if you want to go ahead and let's take a look at that.
All right. Well, I've tried in this presentation, again, this is not complete analysis that would be done, which I believe the Supreme Court will have already done. And for the reason that they will have already done that, I do not see them ruling that the case may go ahead. And you'll understand better what I mean as we go through this. But it's interesting that the Department of Justice was given an opportunity by the Supreme Court to review the presentation, and they declined to do that. Not my presentation, but the presentation of the case. After they reviewed it, they said, no, we don't need to waste our time, because we know it's going to die infant mortality or whatever in the Supreme Court on January 6th. And so the Department of Justice is not even considering reviewing the case. And the Brunsons have looked at their lack of interest in reviewing the case as the Department of Justice as a sure thing of their victory, because they feel like that the Department of Justice has rolled over and played dead. And I don't believe anything could be farther from the truth. I think that they have reviewed it.
Have there ever been any historical precedents for when the Supreme Court not reviewing something in advance, as you're describing?
Oh, well, this one, as it's brought forth, is what they're going to have on January 6th is a discussion. And the Supreme Court justices are going to say, is this come on our caseload this year? And if it does, we'll put it on our agenda, and we'll get to it, and we'll do a full review of it, and we'll make a decision. It would probably be announced in June. Let's just put it that way, like they often do at the end of their session. But these things come up all the time. I know of one year they had something like 150 something of these type cases come up, and they accepted one. So yeah, it comes up, and they do a kind of a cursory review, or as much depth as they think they need it, and then they say, this doesn't fit, we're not going to do it, and they shut the books, and they move on to the next one. And sometimes it's a pretty open and shut and very brief, and other times they spend a little more time on it, but it's not unprecedented at all for a case to get to this point and then have it, we're not going to look at it. And they say, no, thanks. And so this is just because it's where it is, does not mean this is going to get a full hearing. It does not mean it will get anything, anything more than just a, okay, moving on. And it may be almost that brief. But the Brunsons believe that because the Department of Justice has said, no, we're not even going to present in this matter as to whether or not it's important. They say, oh, there they go. We've got them tied up in a bag, and we're ready to throw them over our shoulder and take them home. That is, I don't believe that's how the Department of Justice or the Supreme Court is looking at this. The Supreme Court will look at this through a lens of, what does this do? And if in fact they need to take the case and bring it forward, they will. I do not believe that they will. But in the chance that they do, then I'm going to have to hold my breath a little bit longer, because I'm very concerned what the outcome will be if they do go forward. But I don't believe it'll go beyond January 6th. In spite of the glowing, hopeful, almost euphoric view on things, I think we got to kind of peel the onion a little bit. And again, in the brevity of this presentation, you just have to kind of, you'll get I think, a pretty good flavor for what's going on. So what the case wants to do is carry something forward that the patriot community really believes is going to correct the November 2020 election injustices. The patriot community is just jumping at the bit to do this. It's been before two lower courts, and you can see on the slide, those two lower courts had judgments entered in February of 2022 and in October of 2022. The 10th Circuit Court of Appeals was the last one to look at it, which they finished in October of 2022. They dismissed, the two lower courts that have looked at this dismissed the case without prejudice, which means it could be refiled. Now, the fact that they've already found it had no merit has not dampened the enthusiasm of the Brunsons in carrying this forward. Both of those courts said this does not hold water, okay? But they're saying, oh, we get to carry it forth to the Supreme Court. So it has been filed as a potential case to be heard before the United States Supreme Court. That's where it is now. It's not one that they've said we're going to carry it forward. So they've scheduled a meeting on January 6, 2023 to discuss whether or not they're going to review the case. The meeting could result in the case being selected by the Supreme Court to be heard as one of their cases this year, or it could result in it being set aside with no further recourse. And if rejected, though, the Brunsons have already said that they'll try to resurrect the matter with a parallel case founded on the same basis of thought that's currently in the 10th Circuit Court. Now, my personal opinion on this is that the 10th Circuit Court has already said, okay, look, a case that's so similar, they're Siamese twins, is before the Supreme Court, or as a potential before the Supreme Court. If they decide they're going to rule on it, it'll make this issue a moot issue. If they say they're going to kill it, we'll kill it too, because we don't think it has any merit. That's where I think their logic is. But the Brunsons have said, if this one does not make it into the Supreme Court caseload this year, we have another one behind it that we're going to bring from the 10th Circuit Court if they rule against us. Okay, so this may not go away immediately, but the case wants to remove 388 national elected federal officials, remove them from office. And that's basically all the elected Democrats in the House and the Senate. There's a few selected Republicans in the House and the Senate that they want to do that. Their judgment factor, we'll see in a minute, why they used so few Republicans and so many Democrats. But they also want to get rid of Joe Biden, removed from office. They want to get rid of Kamala Harris as vice president. They want to, and this one is, he's not currently in office. Former Vice President Pence would be, of course, found guilty and then barred from future office too, if this was carried out. And we'll see that as we go through this presentation. And then they've also thrown a big net to make sure if there's 100 more John and Jane Does out there, we want to make sure that we've got a place to put them in this too. It's a pretty severe outcome. It seeks to apply the 14th Amendment. It's a clause that was in the 14th Amendment as a retribution against those that participated in the Civil War. This 14th Amendment was post-Civil War, and they took this retribution against those that were participating in the insurrection, as they call it, against the United States during the Civil War. So it's basically they're saying that they're prohibiting individuals, current individuals, as the 14th Amendment would call them, from holding an office that have taken an oath to the Constitution and engaged in insurrection or rebellion or given aid and comfort to enemies of the nation. They're using that 14th Amendment clause. They're also applying some other amendments that are there to assure due process and right of petition and redress of grievances. We could talk at length about where some of these things are clearly misunderstood by many Americans that claim to love the Constitution, and they tie it back to the Magna Carta, clear back in 1215, and point 61, if anybody wants to do any research and look that up, about the opportunity to basically burn the castle down if they don't do what you want to do. A lot of these things are not soundly founded in US jurisprudence or in constitutional protocols, but that's what they want to do. And they use the vote to certify the electoral votes on January 6, 2021, that they're finding cause for fault. They're saying that these individuals that they want to oust from office did not investigate potential voter fraud, and that decision demands that they are removed from office. So we'll see how this develops out as we go forward. It claims that this unwillingness to investigate the fraud is an act of treason and fraud perpetrated by those who are unwilling to investigate. Now, we're going to just tell you what treason is shortly, and you'll have to be thinking about how this might fit in this process that we're going through. They also say that unwillingness to investigate the vote fraud is an act of war, and it has the same results on the nation as if it had been an act of war. So there's some pretty heavy duty weights that have got to be carried around on this. So they said that by them doing this, it resulted in an unprecedented national security violation against the nation and the citizens. And they claim Brunson to be one that had this egregious action taken against him, and therefore he has standing. Now, you're going to find a whole bunch of things in my kind of key words here, without me trying to define every single one of them, that the Supreme Court could use to say, we're not going to go forward with this. But they're claiming that that Brunson, that is named in this, is the one that was harmed by these actions. And in essence, they're saying the nation and all the citizens were too. But they say this is so egregious and so imperative that it be happening. They want immediate removal of these elected officials from their office. Now, you saw the list earlier. Virtually every Democrat that's in office, that was elected to office, would be removed at the federal level. Okay, so they want to apply Title 18 U.S. Code, Section 2381. That defines treason and the punishment, okay, as the justification for the action they're taking. We'll quote directly from that. It says, whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States. Okay, that's pretty heavy duty stuff. It really is. Just to give you some idea how heavy duty it is, it's only been applied about 40 times in the nation's history. Okay, in all of our history, what's interesting is in this suit, they're seeking to apply this code of treason against 388 elected officials, plus 100 more John and Jane Does, in one single Supreme Court action. Okay. Now, we're going to see shortly, I hope, they'll be able to connect the dots, if you will, that the Supreme Court is stepping over a boundary that, if it happens, our separation of powers will be dissolved. If 5 Supreme Court justices can eliminate, essentially, the elected officials that are in the legislative, we don't have a legislative body anymore. And they're going to take action against the executive. Holy cow. We don't have any executive branch anymore. And see, you say, oh, we got 9 Supreme Court justices. No, no, no. If 5 rule as a majority, 5 would rule the nation, an oligarchy, total destruction of the Constitution. So now, levying war against the United States is defined as taking up arms against the United States to overthrow the government or prevent it from carrying out its lawful functions. So adhering to the enemies of the states, and again, we're going back to the definition that we're finding under the title that they're trying to bring forth, includes providing financial support to a country that is at war with the United States, giving sensitive information to a country that is at war with the United States. It's interesting, to be convicted of treason, one must have committed one of these acts with the specific intent to betray the United States. And one must have intended to help the enemy, not just that their actions had that effect. So this intent thing is a pretty heavy or high bar to get crawling across.
So in a court of law, there would have to be individual evidence for each of those 388 people. Is that shows where their mind and intent was? Would that be
you're
right?
going to have to see, people need to think about this for a minute. To throw a big net out and say 388, yep, that's guilty because they did this one thing. They didn't investigate the possibility of fraud. And do you see, this intent thing becomes it's very hard to come to grips with this. And I think the Supreme Court is going to see a lot of these things. I mean, if someone is kind of mundane as myself can come up with some of these things, I suspect that some of those clerks that are pretty bright people in the Supreme Court are going to say, you know, Justice so-and-so, here's a thought or two, okay? So that intent thing is going to be a pretty high bar. But in addition to that, it goes on. It doesn't get any better ever once within this presentation. Historically, treason has been ruled by the courts to, it's only possible when an action is carried out in behalf of an enemy during a constitutionally declared war. Now, some of you in my age category might recall when Jane Fonda went to Hanoi and sat on anti-aircraft weapons and gave aid and comfort to someone that was, obviously, we lost 58,000 Americans and had hundreds of thousands of them maimed and millions of Vietnamese killed in it, but it was not a constitutionally declared war. So nobody could say, well, they could say it. A lot of us did say it. Jane Fonda was guilty of treason, but it did not apply based upon how the courts have applied treason and the constitutionally declared war issue.
So yeah, that is a pretty high bar. We haven't declared a constitutional war since World War II on anything. And to have that precedent from the Vietnam War, that's quite a perfect storm there of not looking so good.
Well, you know, some of us, you know, that were serving during that era were appalled to see Jane sitting on an anti-aircraft weapon. I don't believe she was actually firing it at American airplanes or anything like that, but still, it looked pretty treasonous to a lot of us, and that's consequently why many in my generation still say we're not fond of Jane. But this is a thing that is, we got 388 people and maybe 100 more. We don't know because we don't know their names, who are kind of on the chopping block because of this. And this really fine strainer they got to get through doesn't seem like the Supreme Court's going to take a lot of liking to it. But in addition to this, there's some pertinent constitutional considerations that need to be discussed and brought forth. So what I've done in the next little section is I've taken clauses out of the United States Constitution. The slides are pretty well self-explanatory, but I may make commentary briefly on some of these to kind of help connect the dots, if you will. So let's go first to Article 1, Section 2, Clause 5. Remember, forever, I hope, that Article 1 is basically the job description of the legislature. Article 2 is the job description of the executive, and Article 3 is the job description of the judiciary. Okay, so here we are in the job description of the legislature. The House of Representatives, okay, so that's the guys and gals that are in there for 2 years at a time, shall choose, that's the original spelling, by the way, their speaker and other officers, and shall have the sole power of impeachment. Okay, now what a lot of people have kind of equated this Brunson case to is like an impeachment, okay? An impeachment. Now, impeachment really is a bringing of charges. It doesn't remove anybody from office. It's like an indictment. So the House of Representatives has the sole power of impeachment. No, wait. The Supreme Court might be trying to carry out an impeachment. In this particular case, we're going to find that doesn't fit the category. And in addition to that, we're going to find that how they do not have any power whatsoever to remove anybody from office in these other departments or branches, okay? So just kind of keep these things sorted as we go through this to see, is the Supreme Court going to say suddenly, oh, yes, we can impeach or carry out all of these removals from office or anything like that? It just, well, and the fact of the matter is that constitutional protocol does not allow any redelegation of authority that is constitutionally delegated. Like, for example, let's take Article 1, Section 1. The first lines basically says that all legislative authority herein granted is granted to the House and the Senate. All legislative authority. Nobody has any authority to legislate. Now, you point out that sometimes an executive will legislate through executive order, which is unconstitutional. The court may create law based upon a court edict. It violates a protocol that says you cannot redelegate. John Locke made a magnificent statement about this that all the founding fathers studied and understood. And Jefferson made some more expansive statements about it too. You cannot redelegate authority that's delegated by the people through the Constitution to a given branch or department. You can't, Article 1, Section 8, Clause 11, for example, delegates the authority to go to war to the legislature. Article 1, remember, it's their job description. No one else can take us to war. You can't redelegate that to the executive, not through a treaty. Nowhere can it happen. And I know that violation happens constantly. But this thing that's happening right now, right before our eyes, has never happened before. The Supreme Court has never had before them a case that says we're going to give you the chance to eliminate the legislative branch and eliminate the executive branch, at least the people that are in the offices. So let's go on with this a little bit. So the House can bring charges. Okay, that's what an impeachment is. Okay, Article 1, Section 3, Clause 6, that has to do with the Senate. The Senate shall have the sole power to try all impeachments, not the Supreme Court. It doesn't say, oh yeah, but it does say a senator. The only time anybody that's in the Supreme Court is involved is if the President of the United States is tried, the Chief Justice shall preside. Okay, so the Senate sits, if you will, as the judge and jury, but the Chief Justice presides if the president is going to be impeached, okay? But they don't take everybody out of office that gets brought under charges and then tried. It has to be a 2/3 vote of the Senate, not 5 justices, okay? Do you see how we've got this thing is completely egregiously violating the Constitution?
If this case goes through, as people hope, it will fundamentally redefine how this power functions simply through the act of doing it for the first time.
Oh, absolutely. But it'll be more than just redefining it. It will de facto say the Supreme Court can decide anything and everything. We can get rid of those pesky legislators and we get rid of that pesky executive, and we'll just do it. And by the way, this is kind of a parenthetical remark, but many people probably know the running gun battle, if you will, in kind of a philosophical sense, between some of the presidents and John Marshall, the Chief Justice of the Supreme Court, in the early days of the nation. And at one point, Andy Jackson, as president, had been doing some egregious, horrific things against Native Americans, and the Supreme Court ruled against him. And In essence, what Jackson said was, now John Marshall, remember, was the Chief Justice. So what he said was, Marshall has his ruling. Now let him enforce it. And he went on with whatever he was doing. Now, he shouldn't have been doing what he was doing. Okay, I'm not in any way, shape, or form giving credence to that. But how does the Supreme Court get rid of 388 duly elected, officials, virtually the entirety of all elected Democrats in the general government, at the federal level? How are they going to enforce it? Are those justices going to walk over there in their black robes and usher them right out of the House and the Senate? I don't think so. There's no enforcement arm. The executive has the enforcement arm constitutionally. It's something to think about. Again, connecting dots. Okay, let's go on to Article 1, Section 3. Again, in the legislative job description. All right, judgment in cases of impeachment. Okay, so this is if the Senate does say, yep, you're guilty, shall not extend further than to remove from office and disqualification to hold the enjoyment of any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, and judgment and punishment according to law. Okay, this is not a one fell swoop has all these things happen. If it were an impeachment, which it is not, it does not constitutionally qualify as an impeachment, then you'd be kicked out of office. Then you could be charged before the law. But this treason thing that's carried out is another step that the case is requesting the Supreme Court carry out. Again, another challenge. Let's go to Article 1, Section 5. This has to do with how the House and the Senate do their business. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. What? You mean it takes the House 2/3 to decide if somebody gets kicked out? Can the Supreme Court do that? It doesn't say that. There's a separation of powers there. So the House can kick people out if they vote 2/3 to do that, but nobody else can. And that's why we've got to choose wisely who we send into these House of Representatives and the Senate. But it doesn't say that 5 judges on the Supreme Court can decide to expel a member. It doesn't say that. Okay, let's go over here. This is still in the legislative job description. Senators and representatives shall in all cases except treason, felony, and breach of peace be privileged from arrest during the attendance at the session of the respective houses and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. What? They're above the law? Are you kidding me? Here's what the origins of this was. Sometimes the king used to, when something was going to come before the parliament, the king would say, golly, I know how this guy's going to vote. I'll arrest him and put him in jail so he can't get there and vote his vote. King wins, okay? They needed to have an autonomy between the departments. The concern was maybe the president, maybe in this case the Supreme Court, might get too big for their britches. They may decide they're going to grab some of these senators and congressmen that aren't on their side or don't believe the way they do or whatever their excuse is, and suddenly they're going to arrest them, and they may even put them in jail. You never can say. But it says in here, they shall not be questioned in any other place. Okay, so the House and the Senate were together to certify this thing on January 6, 2021. Just another thing to think about. Were they under the protection of Article 1, Section 6, Clause 1? If in fact they were, then the Supreme Court is going to say, by golly, we can't touch them. Okay, just think about these things. Here's an Article 2, Section 4. This is, remember, the president's job description. And it says this: the president, vice president, and all civil officers of the United States, that's everybody, okay, all of the people like Supreme Court justice and everything, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Okay, so here we are. We're having, in this case, an attempt to get 388 at least, maybe 100 more, kind of pulled out, strung up, and cast aside because of these things. But no, wait, this isn't a real impeachment. It didn't go through the House of Representatives for impeachment charges. And it didn't go before the Senate to be tried. No, it didn't. It's really interesting how this thing is being spun. And again, without going into the nuances of this, you just need to understand there's enough question. Now, here's an instance where the Supreme Court could have been involved. We're in Article 3. It's the job description of the Supreme Court. This could have, and in my opinion, should have happened just post-election. So between the election in November and what this thing happened, when the new Congress was seated to certify the electoral votes, if, and they did, any state or multiple states filed suit against another state, then the Supreme Court could intervene. Okay, so if some states said, by golly, I don't think that there's been fair elections happen in this state, and we're going to sue to discover that. Some did. And the Supreme Court declined to look at it. I believe they were remiss. And that's neither here nor there on the effect that they could have and they didn't. So that tells me their inclination to intervene on this thing is probably at a very low level. They already had a chance right after the 2020 election when states went at each other claiming that there had been fraud or inappropriate actions or whatever that happened in the election. The Supreme Court had jurisdiction and they declined it. Going on into, so we're in Article 3, Section 2, Clause 1. Let's go to Clause 2. In all cases affecting those in which a state shall be a party, the Supreme Court shall have original jurisdiction. See, the states, when they went after each other, it went right to the Supreme Court. Supreme Court said, no, we ain't going to do it. No. What does that tell you about their interest in this kind of thing? They could have, but they didn't. Okay, let's go on to Section 3 in Article 3. Again, this is still the Supreme Court job description, if you will. In this location, treason is defined. Okay, now, treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. All right, what the heck? Where did that come? The king used to declare, this is treason, this is treason. Let's arrest these guys. And so they arrested him. They took Parliament out of action again or whatever, or some common citizen that just had a disagreement with the king. Treason is very, very, very narrowly defined in the Constitution. And again, we've read the definition of treason earlier, but constitutionally, this is how treason is determined. Okay, let's go to Article 4, Section 1. This is another thing that might enter into it. And again, we could debate and discuss this at length, but it states that full faith and credit shall be given in each state to the public acts, records, etc. of that state's actions. Okay, now the Supreme Court may go, Pennsylvania certified their record as a state. Their state designated process certified the electoral process that went on in their state. Michigan did too, and so did Georgia and whomever, okay? They may come to say, are we stepping on states' rights if we do this? Because these things were certified within their states. Just a thought too. Okay, here's another Article 4 thing. Excuse me, this is Article 6. It says, this Constitution shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. So it's the supreme law of the land. So all of these things we've been talking about thus far are considered the supreme law of the land. Regardless of what other statutory something has been put in place, the Constitution is paramount to that. It's superior to that. Okay, so supreme law of the land. Let's go on to Clause 3 under Article 6. Judicial officers, both in the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Here's the deal. If the Supreme Court is going to stand in their place as they should be, they've got to keep all of their actions within this Constitution also. There is nothing in the Constitution that says the Supreme Court can jump across the aisle or across the fence or whatever is there and eviscerate the legislature or the executive. Can't do it. I think they're going to be loath to do it. And honestly, I think if you eliminated every elected Democrat in the national level, there's going to be some kind of comeuppance that people decide what they're going to do. Here's what I'm concerned about, though. With the enthusiasm that so many in the so-called patriot movement have for what the Brunsons are doing, when it gets deflected, I'm concerned that some cataclysmic disappointment might be there. And I hope that wisdom prevails, particularly since if the Brunson case prevails, we will have lost our Constitution, in my opinion. Well, so the Constitution divided and subdivided the powers that were delegated. They're separate and co-equal. The legislative, executive, and judicial are separate and co-equal. Nobody lords over the other one. James Madison wrote about this. They need to jealously protect these separate spheres of delegated authority. If you're an attorney and you're in the legislature, you've got to take the role of the legislative. You can't, just because you were trained for the ministry as a legal beagle, say, oh, I'm gonna take the judiciary over the. No, you have a role to play. You come into that and you follow your role in Article 1. Okay, and all of those need to go through that. Here's what Madison said. The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. So, if the Supreme Court jumps in, they're consolidating.
We are growing tyranny through this case if it succeeds, because we are consolidating powers in one branch.
Absolutely. And here's another statement by James Madison. You can go back to Federalist 51 and read. But the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. The provision for defense must, in this, as in all other cases, be made commensurate with the danger of attack. Ambition must be made to counteract ambition. The interests of the man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? Humans tend to seek to obtain and then later abuse power. Every branch, just think for a moment. If the Supreme Court said, all right, you guys in the legislature, you're out of the office. First of all, how are they going to turn them out? They don't have any authority or power to do that constitutionally. Second of all, the legislature would be fully within their rights to defend their legislative position as a separate co-equal branch of the United States government.
In fact, the most constitutional thing they could do is tell the Supreme Court, no, go pound sand, and defend the integrity of the legislative branch. So
Absolutely.
Ironically, it's the defense of the Constitution that would actually kill this case, not the other way around.
Yep. See, I'll go back to Andy Jackson again. Don't get any idea that I have a great deal of overwhelming admiration for him. He did some good things, like get rid of the first Federal Reserve, but that's another story if we want to talk about that. But when he vetoed the renewal of the Federal Reserve Act, it wasn't called that in those days, but you'll understand today. When he vetoed the renewal of that institution, it's not a department of government, it's a wholly owned, privately owned, for-profit banking institution. But Andy Jackson vetoed it. Well, the legislative could not muster a veto override. And so they decided, what are we going to do now? Let's impeach him. Well, they couldn't get together enough to impeach him. So what they decided they were going to do was they were going to censure him. And Andy Jackson, for all of his faults, pushed back in a very constitutional way. He wrote a very scholarly, and you should look this up and read it. I highly admonish everybody to, but they need to look up and read what Jackson wrote. He says, yeah, you can impeach me and you can try me and you can remove me from office, but you can't censure me. Take a hike, pound sand, whatever you want to call it. Okay. Andy Jackson was a guy that fought duels and he always won, even though he got shot sometimes. But at any rate, that's the way it is. His executive office had to push back when the legislative said, we're going to censure here. And he said, no, you can't. Carefully read the Constitution. It's not in there. Okay. So this whole thing we've been talking about and this supremacy of the judiciary, Jefferson had a lot to say about this. Okay. Here's a few statements, and then we probably ought to bring it to a close. He said the Constitution meant that each coordinate branches should be checks on each other, but the opinion which gives to judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and the executive also in their spheres, would make the judiciary a despotic branch. Now, this runs counter completely. Like I say, we've got a lot of attorneys in the legislative branch. And there's been plenty of examples of attorneys in the legislative branch. They'll say, let's just pass this and see what the court does with it. No. The legislative branch has a responsibility to keep things within constitutional limits. And if they pass it, they violated their oath of office. And if the executive was going to sign it, he has to look at it too in the light of the Constitution. And if he signs something that's unconstitutional, he has violated his oath of office. Okay, this is just amazing. And Jefferson's saying, no, they're not supreme over anybody. We all have that responsibility, and we can bring plenty of quotes to show that. But the fact of the matter is, here's another one. The question whether the judges are invested with the exclusive authority to decide on the constitutionality of a law has been heretofore a subject of consideration with me in the exercise of official duties. Certainly, there's not a word in the Constitution which has given that power to them more than the executive or legislative branches. So every branch is really co-equal. Another statement, it's a few slides long, we'll be done here. To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. That's those 5 judges we talked about earlier that would be in the majority. Our judges are as honest as other men, and not more so. They have with others the same passions for party, for power, and the privilege of their core, and their power is the more dangerous as they are in office for life and not responsible as the other functionaries are to the elective control. The Constitution has erected no such single tribunal, knowing that to whatsoever hands confided, with the corruptions of time and party, its members would become despots. It has more wisely made all the departments co-equal and co-sovereign within themselves. The Constitution, in keeping 3 departments and independent, restrains the authority of the judges to judiciary organs, as it does the executive and legislative to executive and legislative organs. When the legislative or executive functionaries act unconstitutionally, they are responsible to the people in their elective capacity. The exemptions of judges from that is elections, they don't get elected, remember that, is quite dangerous enough. I know of no safe depository of the ultimate powers of the society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. I got one more slide, but I want you to take a thought about that. Don't seize the elective power from the people and cast out from office whomever they have placed there by a branch that is unconstitutionally going to possibly do this and unlikely do it, I'm saying. But you don't do that. Don't take it from the people, but inform their discretion by education. So the people need to understand these limits and bounds. Final slide. This is the true corrective of abuses of constitutional power. If the 3 powers maintain their mutual independence of each other, the government may last long, but not so if either can assume the authorities of the other. So said Thomas Jefferson. So here we have outlined in brief, and probably to some people's opinion, not briefly enough, But this is a momentous time in history, and a great many, I don't know what percentage to put on it, probably at least 95% of the patriot organs that are out there, whether they're written or they're blog talks or whatever, are euphemistically dancing in the street of what might happen with this. My position is connect the dots, people. If this happens, what have we done? What has happened to this nation? I mean, people have told me, oh, yeah, Trump's going to be the rightful president suddenly. Or the military's in control and they're going to be in complete control. What you're going to see, if that happens, is a military junta, like a tin horn dictatorship in South America or some silly thing like that, where nobody remembers what I term the deconstruction of the South after the so-called Civil War, where it was a conquered land. The military ran it. Military tribunals run the courts. They had summary executions. Whatever happens, the discipline of the justice that we have found in America was suspended. The idea of due process, it didn't have to happen. The Constitution was no longer in effect in the South after the Civil War. We don't want that. We would like to have the rule of law, which the Supreme Court needs to recognize also, that being the supreme law of the land, the Constitution, and not violate it. Now, I'm hoping and praying that wisdom prevails, and I think it will, but holy cow, I don't know what some of these patriots that are so absolutely on a bubble are going to do about this when it happens. The real challenge is we the people. I mean, and a lot of times people don't want to take that responsibility. They want somebody else to take care of this Leviathan that's out of control. It got out of control because of us. We have been so complacent and so complicit. We sell our votes to the highest bidder, if you will, just like right now happening in the House of Representatives, this wrangling to become the Speaker of the House. They're dealing out cards like, you get to have this chairmanship if you'll vote for me now, or whatever. The principle is the principle, and that's what we've got to stand with. And when we violate principle for some kind of other largesse, and we do it all the time as a people, we get the kind of government we deserve. We must restore an understanding, a sound understanding, and then we the people must restore it. If the elections are fraudulent, if they're improperly carried out, we've got to fix the elective process, and that entails getting away from everything that happened in the 2020 election. Everything, this university mailed out ballots and drop off ballots and harvesting of ballots, and
right, all of that
chain of control of everything. No, we go back to the paper ballots in person on one day. Someone can request a ballot if they have a reason, and then there's a process, but that'll be so small it's easily controlled. But everything that happened in the 2020 election, if it becomes canonized, and I might also add that we could go back constitutionally and discuss that the intent of the founding fathers was that the election process was to be controlled within the states. And every single step that's happened, whether by amendment or a voter rights code that was put in place, has been to seize power from the states and take it to the general government level. And it hasn't gotten any better. So we've got to go back to the way it was. We, the people, need to understand these things, become conversant in them, and become engaged and involved to restore the foundation of this great constitutional republic. And if we do this, we can save it. The Constitution still exists. It doesn't need to be changed. It's not at fault. It's because it's not being applied. So the oath of office in Article 6 is something we've got to go to instead of changing the Constitution in Article 5.
Right.
Let's start applying it, not just avoiding it and rewriting it.
So applying the Constitution is the solution to defend the Constitution, to restore the Constitution. But most people don't know it. They let things slip by because as a people, even those of us who love the Constitution oftentimes don't know it. So how can we defend it? So I would invite anyone of our listeners, please join with us. We have Dr. Bradley every week giving a constitutional deep dive on a principle in the in an effort to help more of us become educated on that. So I hope many of you will take advantage of that. That's go to our website, defendingutah.org/membership, and also check out Freedom's Rising Sun. That's Scott's website, and he does a great Thursday constitutional analysis of current events. And we hope that these all can be powerful tools for you guys as listeners. So I think we probably should wrap up. We've done a lot. And any other last comments you want to give, Scott, today before we go?
Well, just a very, very brief sum up. Just to tell people that maybe viewing something that we do together for a very first time, coming to know us. I've told this story before to some people, but I think it makes a point. And that is that back when I was 6 years old, I got lost. And it was terrifying. And my first impression, which I followed, was to run. And I guarantee I didn't know where I was going, but I was making good time. But I also guarantee that falling down in the river and tripping over deadfall and boulders and getting caught in the briars and the brambles, that does not make for safety. It makes it worse. And since that time, I've learned that really the first thing you do when you get lost is you sit down. You look at your back trail. You evaluate your resources. You don't panic and you don't lose your mind. And you'll find your way back. Your back trail is a lot easier to find than something through a briar and a bramble that had nobody walked through for the last 1,000 years. What we have today in America is a well-marked black trail. Our back trail is well known. We had at one point the greatest, freest, strongest, most happy, most prosperous, and most respected nation in the world. We lost that as we diverged from our trail, but it's well marked and it should be well understood. It's written in plain English. English words have a meaning. Those meanings can be known. The only meaning they can have is what they meant at the day they were written. And if we take that back trail, we'll find our way to safety rather than following some path that's never been crossed before that really has a lot of risks. So I'll turn it back to you.
Great. Thank you, Scott. I absolutely love that analogy. It's a very strong visual. And so many people are looking for, what do we do? How do we fix this? Well, the trail's been marked, as you said. I absolutely love that. So thank you for your time today. And thank you everyone for listening. And we'll catch you next time on Defending Utah Radio and Television.